At this time, the Tuesday, April 26th, year of 2022, meeting of the Citizen Review Board is now called to order. If you will, please rise for the Pledge of Allegiance and remain standing for a brief moment of silence in commemoration of the recent passing of our colleague, our passing clerk, Ms. Debbie Mercer. May God rest her soul. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Madam Clerk, if you will, please conduct the roll call.
Banks. Present. Collins. Tamayo. Present. Reyes. Guy. Akil.
Present.
Ingandela.
Here.
Valdez.
Present.
Irvin.
Here.
Let the record show that all members of the Citizen Review Board are present, with the exception of Ms. Irene Guy, our Vice Chair, Mr. Reyes, and Dr. Carolyn Collins. At this time, I would ask Mr. Valdez to sit in as acting Vice Chair for the absence of Mr. Reyes. And if you will, please continue with the meeting guidelines.
Thank you, Mr. Chair. Please silence all electronic devices. The duties and responsibilities of the Citizens Review Board are to review completed department investigations involving use of force and cases of importance and interest to the community or the city. Determine whether the disposition of review cases was consistent with department policies and procedures. Review matters of importance or interest and make recommendations regarding the handling of these matters. Determine whether any revisions or additions to department policy and procedures are appropriate in reviewing matters of or importance or interest, and report findings and recommendations to the mayor and chief of police. Cases that are brought before the Citizens Review Board are closed internal affair cases that have been investigated and brought to the police chief for disposition. It is the Citizens Review Board's job to review the cases and render an opinion as to whether the investigation was done according to the department policies and procedures. The Citizens Review Board members are provided the investigative files in advance of the meeting. The Citizens Review Board will hear from the department whenever matters of interest or importance are requested for review by the board or the department. As will be further discussed by the chair, members of the public will have an opportunity to address the Citizens Review Board during the public comment portion of the meeting. The coordinator for the board is Captain Patrick Mesmer. Any person who wishes to make a complaint concerning a matter which may be considered by the Professional Standards Bureau should see the captain for information on how to file a complaint. The chair is responsible for maintaining an appropriate, business-like decorum during the meeting. The board should not discuss matters where the city or the department may likely be a party to litigation. The public comment portion of the meeting is coming up early on the agenda, so if you wish to speak, please line up at the kiosk now so you can be called in order. Please maintain social distancing and wear your mask.
Thank you, Mr. Valdez. We'll now move on to item Roman number 4, approval of the minutes from the meeting of March 22nd, year of 2022. Are there any questions or provisions? Hearing none, I will need a motion and a second to approve the minutes.
Move to approve the minutes of last month's meeting. Second.
Board Member Tamayo has made a motion to approve the minutes of the Tuesday, March 22nd, 2022 meeting. Board Member David Ingandela has seconded the motion of approval of the minutes for the Tuesday, March 22nd, 2022 meeting. Any further discussion? We'll now continue with the vote. All in favor, please show by raise of hand. Thank you. All opposed, please show by raise of hand. The motion passes. Thank you. We'll continue with the agenda to Roman numeral 5, public comment. Are there any participants signed in for the public comment portion of this meeting?
There.
I will now ask whether there were any recorded comments received through the voicemail set up for this meeting.
No, sir, no recorded comments.
I will now ask if the clerk received any written comments for this meeting.
No written comments.
For our viewers at home, those who wish to participate in the public comment portion of our meeting and are able to be physically present, know that the website to send in your comments will be T as in Tom, P as in Paul, D as in Derek, -crb@tampa.gov.net. That would conclude the public comment portion of our meeting. We will now continue with Roman numeral 6, staff and board response to public comment. I will ask board members to share if there's any dialogue in reference to past public comments that you wish to share with us at this time.
Mr. Chair, Kamaria Pettis-Mackle from the City Attorney's Office. Since there were no comments this evening, should be no responses for that item. We can move on to the item on the agenda to be reviewed.
I have a question, Ms. Kamaria. Are we able to comment on past public comment participants in dialogue?
That wasn't received today.
Okay. Thank you. We will continue with item number 7, items to be reviewed. Tonight we'll be reviewing case number 17R-001.
Chair, item number 7 is approval of the modified rules of procedure.
We amended the agenda.
Amended it? Okay, sorry.
Thank you, Mike Schmidt.
Good evening. Captain Patrick Messmer, Professional Standards Bureau. So the case that was selected to be reviewed this month, this was a officer-involved shooting case that occurred back in 2017. And again, the reason that we're looking at a 2017 case is we do, based on the rules, the board does not review anything where the city could potentially be party to litigation. There was a 4-year statute of limitations in an incident like this where the individual shot survived. So since that statute of limitations period has now expired, that case was now available for board review. So this specific case involved a canine officer. And this was a case that was required by policy. There wasn't an actual allegation of any kind of misconduct. Anytime an officer discharges their firearm in the line of duty, we are required to conduct an internal affairs investigation in regarding the circumstances of that use of force. In addition to that, there's also a review done by the state attorney's office as to the legal justification of the use of force. So currently, when an officer discharges their firearm in the line of duty and shoots somebody or intends to shoot somebody, the Florida Department of Law Enforcement will handle the criminal investigation, and the Tampa Police Department Internal Affairs Unit will handle that internal investigation. Back in 2017, and I'm just going over this because you were provided a lot of documentation about this case, you probably noticed that it was actually our homicide unit that did the criminal investigative part of it, and the Internal Affairs Unit also did the administrative part. So that's why there was that difference, because in 2017, we did not have FDLE investigate our shootings. We didn't move on to that for several years after that. So that's why our homicide unit was involved in that. Just a little background of the case. You'll also notice that the officer's name has been redacted. The case was written as an aggravated battery on law enforcement officer, so the officer was the victim. So under Marcy's law, the officer's name has been redacted. I know the public has wavered in their opinion of whether or not we should be redacting names of our officers involved in shootings, and that's been a decision by the 3rd District Court of Appeals in Florida that law enforcement officers are subject to Marcy's law. So I know that is a case that's going to be pending in front of the Supreme Court relatively soon, so there'll be a final answer on whether or not that practice is going to continue, but that's just an explanation of why the redaction occurred. So the captain who wrote the disposition letter in this case has retired, so I'm going to present this one. I'm just going to go over some brief synopsis of the case. So we had a officer responded with several different officers to 1022 East 25th Avenue in reference to a burglary in progress. There was a suspect who was still inside, and officers entered the residence by using a ram to breach the door. The known suspect was seen inside with a knife in his hand. The suspect fled into the back of the residence when he was ordered to drop the knife. The officer with the canine entered and confronted the suspect in the garage, and then the suspect was able to ignite an accelerant, which turned out to be primer, and threw that accelerant, flaming accelerant, at both the officer and the canine. It was basically a fireball, which landed on the dog and also landed on the officer. The officer, being in fear for his life, drew his service pistol and fired several times at the suspect. The suspect went to the ground, where he was taken into custody. He was transported to Tampa General Hospital, where he received medical treatment for non-life-threatening injuries. And the suspect later pled guilty to the charges and was sentenced to Florida State Prison, followed by probation. The state attorney's office sent investigators out to the scene as well, and they reviewed the circumstances of the case. They reconstructed the incident themselves, and their review felt that the officer was justified pursuant to Florida statutes in his use of deadly force, and they recommended no charges being filed against the officer. In addition to that, our captain, when we reviewed the internal affairs portion of the investigation, the documents, interviews, and photographs related to the case were all reviewed, along with the policy on deadly force. And the captain found, and the chief and the executive staff concurred, that there was no violation of department policy. And that case was closed as a no violation because it was a required by policy case. It wasn't an actual allegation, so it's not you're not going to see the sustained, not sustained. Nobody made the allegation, so that's why the no violation finding was held.
Thank you, Captain Mesmer. Any questions from the board?
Captain, I just want any citizens who are listening in on this to have a better understanding with the context of this case, that this was not a case of 3 to 4 to 5 police officers simply battering their way into a home with guns blazing without knowing, if I understand the facts of this case, that the officers who first arrived on the scene recognized the vehicle that was parked outside of that home as the vehicle of someone who had several felony arrest warrants out on him. They had actually been investigating this person for the previous week to months beforehand, so they knew what they were dealing with, a potentially armed felon with warrants out for his arrest. Is that correct?
Correct. So he had some warrants for several violent felonies. I know arson was one. I believe aggravated assault was another one. He was contacted by law enforcement at a motel in the area. I believe it was the day prior to that. He fled at that time, and we were unable to catch him. So the officers knew who he was, and they knew what his vehicle looked like. And in this case, when the neighbor called 911 because the neighbor knew that the house next door was vacant because we had an out-of-state owner who was renovating the house. When the officers showed up there, they immediately saw that vehicle, and they noticed that was his vehicle. Then they confirmed that there was a break-in at the house, and that's how they were able to determine who it was and determine that the offense had occurred that they ended up taking him into custody for.
And again, also knew full well, as you've indicated, that the house was vacant. There were no residents in that home at the time.
Correct. It was unoccupied, and they went to pretty great lengths to confirm that with the 911 callers, with the neighbor. I believe they even looked at the property appraiser's website too.
Okay. The facts here seem to indicate that the front door was first attempted to be breached by the officer who was eventually attacked, correct?
I believe it was breached by I don't know if it was him specifically, but officers did try to get into the front door initially, and what they found out later is that the suspect had moved a large appliance in front of the door, and that's why additional officers had to come. One of them had a ram,
Right.
and that's how the door was.
I'm just reading through the supplement, where the officer who was attacked in his testimony indicated, I was unsuccessful, so they had gotten approval. They had gone up the chain of command to get approval to breach that front door. And then he attempted, I was unsuccessful at breaching the door, and then he asked Officer Perez to show up with his ram, and then he went ahead and breached the door with that battering ram. My question on this is, when you have approval from the chain of command to breach a door, do the officers have to make any kind of announcement that they're about to breach the door?
They will make announcements, about a specific announcement about the door being breached, not necessarily. But they will, when they breach the door, they will announce Tampa Police, get down, or Tampa Police, open the door, or something like that.
So this fella Kennedy inside the house knew that the door was about to be breached?
Oh, correct, yeah, there were multiple announcements that were given before the door was breached, and even after the door was breached and he appeared with the knife, he was given more verbal commands to drop the knife before he fled back into the house.
Would we want to rethink that in a case where we know that there is a known felon with arrest warrants out for him, that he is very likely the only person in that house? Would we want to give him notice in advance that we're about to go in? I mean, wouldn't we want to go in a little bit, the first sound that he hears is the door being battered without knowing in advance that police officers are about to enter?
Well, there is notice given before. I guess I don't understand specifically your question. We don't say we're breaching the door.
No.
But we do make announcements. There's no knock, nothing like that. We don't operate that way. So there are announcements, Tampa Police, Tampa Police, Tampa Police, come to the door, open the door, before we force entry to anything. But we don't specifically say, if you don't come to the door in 20 seconds, we're going to break the door down. That type of thing.
Yeah, I'm not worried here about the sensibilities of Mr. Kennedy. I'm worried about the safety of the police officers. If we've got a pretty good idea that the only person in that home is this person, whether we want to make any kind of announcement in advance that we're coming in.
Normally, yes. I think legally, it's definitely on the in our best interest to make announcements and announce our presence, just so anybody inside does know that it's the police who are there. It's not somebody else. And in hindsight, it's very clear that he was committing a burglary. There really was no reason for him to be in that house, and he attacked the officers. He attacked the canine as well. But we have seen instances in the past where you do have a person who calls 911 because someone's breaking into a house next door, and we come to find out that it's really not somebody breaking in, it's somebody with permission. So with trying to go and breach doors or anything without making any kind of an announcement, it's just from the liability point of view, we want to make sure that the person inside, even if they're not supposed to be there, they know it's the police. So if something does happen, they can't claim that, well, I didn't know the person I was shooting at was a police officer, because they never announced that they were the police. So very rarely will we not make an announcement. In a case like this, we're always going to, and we're going to be breaching a door. But for some instances, like when our canines are out in the field searching for somebody, if they know that the person is armed and that person has already fled from the police once, sometimes they won't make an announcement in that case. But that's very rare. We normally like to always announce what's going on, so the person has a chance to surrender before they end up getting bit by a dog, or they end up getting shot, or some kind of force used against them.
I just wanted the record to show the extent to which the police department in this particular case went to in announcing who they were and what their intentions were coming into the home.
Thank you, great question.
But in this case, the officers were rather certain that the person in that home was Mr. Kennedy. From the description of the witness who made the initial 911 call and was waiting for the police, the registration of the vehicle, that it was this person who was in the home.
Correct.
I would tend to give that person very little notice that I was coming in. But that's just me.
Thank you, Mr. Tamayo. Any other further questions? During the initial entrance, after the RAM entry, officer stated that the suspect was carrying a knife. Was that knife ever identified, confiscated, and titled as evidence?
I believe it was. I don't have the entire report in front of me, but there was a very, very large amount of evidence collected. So I know there were some photographs. I'm fairly certain that it was.
But the reason I ask, if the suspect did not have a weapon or did not have a knife, at that time, the choice of releasing the K-9 may have or may have not been an option.
The release of the K-9 would have been authorized regardless of the knife. You have the known individual who has multiple felony warrants who is not complying. You have somebody who's also committing another felony by burglarizing that house. So under our policies, with probable cause of a felony, we would have been authorized to release the K-9 regardless, especially if he had barricaded the door and then when officers confronted him, he ran into a different part of the house. We would normally send the K-9 in at that point if we thought that the house was, if he was the only person in the house.
And to your knowledge, is there any dialogue in reference to the future with equipping our K-9 units with body-worn cameras?
No.
But the K-9 trainers do have access to that type of technology.
Oh, I'm sorry. You mean, are you talking about the dogs themselves?
Yeah, I'm talking about the dog
Okay, no,
themselves.
No.
But the trainer or the handler of the dog will have access to BWCs.
Correct. The officer, the K-9 officer has a BWC. There's just no way that the dog can't. You have to turn it on and make sure that it's, pointed at a certain direction. I don't know that the dog would be able to. I don't know. There's any way that we could make sure that it would always stay in the proper view, and the dog, especially they do have vests. They do have ballistic vests.
Yes.
So you potentially could put one on that, but it would probably fall over. I'm not aware of any agencies that have even explored the possibility. I know I've had many meetings with Axon, who's our body-worn camera provider. There's never been any solution proposed for even trying to beta test outfitting a dog with a body-worn camera.
Thank you. Interesting point. Any other comments or questions from our board?
I just have a comment.
Very well, Mr. Valdez.
I just appreciate the fact how the investigation ran smoothly and how all departments work together, from the state attorney to internal affairs. So really appreciate the work that everybody put into reviewing this case, and more so it reminds us of the duty that the officers face on a day-to-day basis and how critical and how it could go from 1 minute to another real quick, and, left out of field, and we're faced with a catastrophe with our officers. So appreciate the work put into this case.
Thank you for that acknowledgement. Ms. Kamara, in this particular case, is a motion necessary?
Kamaria Pettis-Mackle from the City Attorney's Office. So as Captain Mesmer stated, for this particular investigation, no violation was found. So if the board is inclined to make a motion, you can make a motion. I mean, just as any other case, you can make there's no discipline involved whatsoever. So you can make a motion to concur or not concur or unable to reach a decision about whether or not no violation was found. But that's up to the pleasure of the board.
Well, I'll leave that option to the board. The chair is open to any type of motion that seems fit.
But again, there's no discipline associated with this investigation.
Any further discussion in reference to the motion in this particular case? Thank you,
Just to ask a question. Sorry.
if you will,
Just,
Dr. Collins.
just to ask a question, sorry, I'm late. Would concur simply say we agree?
You're concurring that no violation was,
Warranted.
that no violation occurred.
Yes, I think she will.
Okay. Well, the chair is open.
Yeah, I would move that we concur with the finding that no violation was found.
I'll second that.
Mr. Tamayo has made a motion in reference to concurring no violation was found. Mr. Valdez has seconded the motion. Any further discussion?
Captain, this is really beyond the purview of this discussion, but would you happen to know how what the disposition was with Mr. Kennedy on those 5 charges?
He was sentenced to, I want to say it was either 3 to 5 years, Florida State Prison, with pretty significant probation after that. I believe he just recently got out of prison.
Really?
Okay, thank you.
With no further discussion, we'll continue with the vote. All in favor show by raise of hand. Any opposed show by raise of hand. The board concurs that no violation was sustained. Thank you, Captain Messmer.
Yes, sir.
Board members, just for the agenda purposes, there's nothing, there's no additional topic to discuss under the community in Tampa 1? Okay, sorry.
Just real quick, I just wanted to follow up on an email that I sent to the board. Wanted to make sure you saw it. Chief O'Connor wanted me to pass along our event that we're doing on Saturday with Rise Up for Peace, the Family Fun Day. It's going to be at Al Barnes Park over on 32nd Street from noon to 5. If any of the CRB members would like to come, the command staff should be out there for most of the time. So just wanted to make sure that invitation was extended. Thank you.
Yes, and for our viewers at home as well, it'll be a great opportunity to engage with our law enforcement as a family fun event as we head into the summer. So I definitely encourage our viewers at home to participate. We will now continue with item 9, CRB staff reports and business. For the point 1, review of TPD SOP 609.9 body worn camera policy.
Again, Captain Messmer with Professional Standards. So one of the items in the ordinance was to discuss with the board and to review any changes to specific policies. We made some minor changes to our body worn camera policy. You know, we started this process several years ago, and over that time, we've learned some things. Some new features have come online from the company. So we have tweaked our policy a little bit to make things a little bit more friendly and to ensure that we don't have video that potentially could not be captured. So to really sum up the changes, in the past, you could do one of two things. Your camera could be on and recording, or your camera could be powered off. It would, and think of them like a cellular telephone. You know, you can, if you power your phone off, you have to power it back on. It has to go up through a boot process, which can take some time to do. So what we ended up doing is there was a new feature called sleep, which would be the same, again, if you have your cell phone and it's on and then you decide you just want to press the button so the screen goes dark. That's basically what it is on the body worn camera. It's a feature to where the officer can still press the button and it will almost immediately start recording again, but it doesn't have to go through the whole power up process. And the issue with that was we don't want video potentially not to be captured if an officer has to power down their camera. And reasons why an officer would power down their camera if they're in the bathroom, because we do have these sensors on the holsters. We have the taser sensors as well. So we have had situations, and the body worn camera units had to delete them, where officers have been in the bathroom and their body worn camera goes off because somebody else who's nearby takes their taser out of their holster, or even at our district office in District 2, which is on 30th Street, if a police car with its lights and sirens goes down 30th Street, all the body-worn cameras in the building would turn on because of the Bluetooth feature that turns the camera on when the lights go on. So that was a real concern with officers in the bathroom or in other situations where everything's private and there's no interaction with the public. They're not engaged in any police function. They're on break, or they're in the locker room, or they're working out or something. So we elected to turn that sleep mode on so we could prohibit them from ever powering their camera down while they're on duty. So if they were able previously to power their camera down, if they got a very important call and they rushed to get back on the street and they forgot to turn their camera back on, you're looking at almost a minute for that camera to boot up. So by activating sleep mode, we've taken that potential problem away, so we're not going to have a delay more than 1 or 2 seconds in video starting. So that's a positive thing. The officers were happy about that because we initially were going to not allow them to power it down at all. That brought up a lot of issues with, well, what do you do if you're in the bathroom and somebody could activate your camera? So that's one feature that I think is beneficial. The other one is another new feature called mute mode. So there are instances where we're having tactical briefings or otherwise sensitive briefings, supervisory conversations, things like that outside of earshot of any citizens or things of that nature. Any kind of discussion that potentially could be privileged under the law. So we've activated what's called the mute feature to where the camera will still record video, but it just won't record audio. So once that tactical briefing is over with, the officers will exit mute mode so both audio and video can be recorded. And that enables them to not, and again, previously they were just shutting the camera off when they were having those confidential discussions. And then the problem with that is somebody could accuse the officer of doing something while the camera was off. Well, now we're at least capturing the video, so nobody can say, well, the officer used force and they turned their camera off before they used force. They really weren't having a conversation. So it's a way for us still to record and know that we're recording the video, but that confidential discussion that's occurring that would be exempt, that we don't necessarily need to capture on body-worn camera, that itself, the audio would not be captured. So those are really the only significant changes to the policy. The camera has to be recording during any law enforcement contact with citizens. It doesn't have to be recording on if they're standing on the parade route at Gasparilla all day. It doesn't have to record all day long, but if they decide to take police action, they have to turn their camera on and start recording that encounter. So really no changes to what we're required to record and what's exempt from being recorded. The only real changes of note were the activation of the sleep mode and the activation of the mute mode. So that's pretty much the overview of the body-worn camera changes.
Dr. Collins?
Just one question on the mute mode. That is only for if they're in discussion, it's not when they're out in the field and they may be recording. Is the mute mode only at that time?
Correct. There's three, let me find it here. There are 3 areas where mute mode is allowed, and these were also areas where previously we've been allowed to completely power the camera down. Where the officer reasonably believes doing so will not result in the loss of critical documentary information, reasonably believes it's necessary to protect tactical or confidential discussions or briefings, or is directed to do so by a supervisor. So those are the only times when mute mode would be activated.
And I do have one more question.
If you will, Dr. Collins.
I won't, because I marked it on my computer and I can't think of how it was. I'll leave it alone. But thanks. And both of them was both for community education, so they would know. Because if somebody say, oh, now they can put it on mute and just have it recorded, I wanted to make sure that they knew that it still was restricted, even if it was, and you said that with your first indicator. And I can't remember the other one.
Well, I definitely applaud the sleep mode activation. It's good to hear that we're still making improvements with our BWCs to support investigations. So we're making improvements in that field, and I'm sure we'll continue to make improvements as technology improves itself. Any other questions or comments for Captain Messmer in reference to the BWCs, in reference to SOP 609.9? Thank you, Captain Messmer.
Yes, sir.
Ms. Kamaria, if you will, I understand under bullet point 2, there has been proposal in reference to our community meetings, which falls under our new ordinance. If you will, can you share those locations with us, please?
Yes, Kamaria Pettis-Mackle from the City Attorney's Office. I reached out to each legislative aide for council members' aide for the single-member districts to ask for proposed locations for our community-wide meetings in those single-member districts. And they provided the proposed locations that are listed on the agenda. With the exception of Chair Maniscalco, he provided 2 locations. And as we see, Councilman Goose, Old City Hall, this location, this building is within his district. So I don't know if there's a need to look at any other locations within District 5 for that area. So I provided these locations on the agenda so that the board members can make a motion to hold your community wide meetings at those locations. Upon approval of those locations, I will work with the council members' aides to actually schedule those meetings according to the council members, if they're available, to attend that meeting. I want to be able to coordinate that specifically with the council members to ensure that they can also attend that meeting since it's in their district. So if we could just simply, I'm open for discussion, but yes.
I have a question, and I reached out to Councilman Good as to why he selected Old City Hall, where we get a poor showing, at least from my experience. Is there not a better location in District 5 for us to meet?
I could ask Councilman Goods if he has another idea for a meeting, and I can get back with the board. But if the board is inclined to make a motion regarding the 3 remaining locations on the agenda, I will follow up with Councilman Goods for that.
I would ask if any of the board members live in these other districts and are familiar with these locations.
I am very, very close to McFarland Park, at the Dave Boxdale Senior Citizen Center. I know where Wellswood, so I'm pretty close to Wellswood. But I don't know the size of Wellswood, but I would feel comfortable in McFarland Park because it's auditorium style. So it's large enough to be adequate enough to allow the spacing we need. And then at the same time, I'm not too in a big hurry to go out to the park.
Well, thank you for that information. And let the record show that Dr. Carolyn Collins, who was pronounced absent, is now present.
Yeah.
The chair is open to the locations that we have established on item 2 in District 6, as Dr. Carolyn Collins just presented, that McFarland Park, according to her opinion, would be a better facility, and there was an or there, so that seems to be a rational choice, being that she's familiar with that particular location. If you will, Mr. Valdez.
So I would agree with my 2 colleagues. First, with the McClure Park, I think would be a better suit for the meeting, and also Mr. Urban, I agree that we already do these meetings here at Old City Hall, so we should look at going out to the community where our residents are, rather having to travel parking and pay for parking and whatnot. It's a challenge, so definitely being able to go out and meet our community members where they're at will be the best way. And I would recommend Alfred A. Barnes Park, which would be it's a great venue to have a meeting of this nature.
For the District 5?
5, yes, sir.
Okay, I'll if we could first address the 3 other locations that I've already provided. I still want to make sure I follow up with with Councilman Goods, regarding any other proposed locations, if that's what he would like.
Ms. Pettis-Mackle, I'm very familiar with the Jan Platt Library, and it's very centrally located within District 4 and very accessible.
Okay.
With great parking too. Yeah, just like that, make sure.
So the chair is open to a motion to approve the specified 3 locations with the exception of District 5,
Before we do
depending
that, can we
on,
put more discussion?
oh, you will, Mr. Irvin.
Yes, sorry, thank you, for recognizing me, Mr. Chair. I spoke with, Councilman Goods. He's okay with Hillsborough, High School, if we can substitute that.
Well, again, I'd like to give Ms. Kamaria the opportunity to speak with Goose
I will.
and get better notification and dialogue and bring that back to the board.
But Mr. Irvin, you said Hillsborough High School? Okay. I will follow up with, Mr. Goods.
In
Councilman
reference
Goods.
to the other 3 locations,
Yeah.
if you will, Dr. Collins.
And if you would ask Councilman Gould, and if it's okay with you in that particular community, right across from kind of Hillsborough High School, is that library, and they have a very large room, and the parking is extremely adequate. Going to the campus on school, then you gotta make sure you're somewhere where you can park and then get people to walk. There have been a number of meetings there in his district, that's at the library on Central, and the name is losing me. Not the one on Nebraska, but the one on
Right.
Central.
It's
You know what
across
I'm
the
talking
street.
about? Yes, right across.
And he was okay if libraries are a approved meeting site, by the city.
So
He's
again,
okay.
Ms. Pettis-Mackle will open up dialogue with Councilman
Yeah, we'll
Goose
go, yeah.
and get back with the board on the 2 locations that was specified tonight.
And I wanted to ask one other question. Forest Heights, Forest Hills, is that a new center? Is it, large, adequate? Do you know anything about that?
I don't know, but this is what was proposed by Councilman Vieira, so he's familiar with the district, and that's what he suggested.
Okay.
So the chair again is open to hold our community-wide meeting at the disclosed locations if board member wants to make a motion.
And I apologize to ask a question on the motion. So for Councilman, the Chair Maniscalco, the board is asking for the meeting to be conducted at McFarland Park. Is that a part of your motion?
Yes. Right.
Okay.
Yeah.
Okay.
Except the only one that's excluded was the one that's still in question.
Councilman Goods.
It's Councilman Goods.
Correct. Okay, thank you.
Was agreed upon.
Okay.
So Reverend Banks has made the motion to hold our community-wide meeting at the disclosed locations, including District 6 at McFarland Park, with the exception of District 5 to be announced.
Second.
Do I have a second?
A second.
Dr. Carolyn Collins has seconded the motion. Any further discussion? We'll now continue with the vote. All those in favor, please show by raising hand. Any opposed, please show by raising hand. That motion passes on the 3 specified locations.
Thank you. Thank you, everyone. I will follow up with the council members to get those meetings advertised and scheduled, and I'll follow up and I'll have the information at the next meeting for District 5 on where that could be.
And will they be after the next meeting? Is that correct?
Yes, I'll check their availability to conduct the meetings, community-wide meetings, after our next meeting, which is May 24th, 2022.
Okay.
Currently under CRB staff reports and business, I assume that we're all aware that our past clerk, Ms. Debbie Mercer, has passed. I wanted to open up the floor if there were any ideas in reference to acknowledging the passing of Ms. Debbie Mercer. Please feel free to engage in dialogue at this time. If you will, Dr. Carolyn Collins.
I just want to make this public comment and hope that the public hear. Mrs. Mercer has been with us for a considerable amount of time. She was the second clerk that we had after the first clerk was promoted. Even though she was gone and told us she was leaving in December, she was still sitting here with Ms. Wilson, and it was nice to see her at the meetings at all. It was extremely shocking to me, and I have this tendency sometimes of being a little bit forward. I know I shouldn't be, but I did. I wanted to get to the service. It all happened so fast, and I was trying to get a card, but I didn't know where she was, because at the time even the article in the paper didn't indicate, where it was going to be. And on behalf of the CRB, because I saw other information indicating that she was a clerk and, where she worked and 20 plus years or whatever here with the city, but there was nothing in there that mentioned the CRB, and she gave a considerable amount of time and service to the short while that we've been here. So I actually did a resolution. It's something that I'm accustomed to in the black church. Might have been a little bit too aggressive, and I agree with a legal counsel here. I had the tendency, mention it for myself, but saying as a member, on behalf of, I think, of the CRB. So I did do a resolution, and I think if we could discuss that, so if something like that happened again, and if that's not what we want, then we shouldn't do it. But it would be the same to me if it was one of the members of the board, either currently or one of our original members, as a salute to that person for the legacy that they contributed to this particular board. So I need to let you guys know I did do it, and I'm not really asking for an apology. I'm just telling you I might have been wrong, or it may have been right, but I did do a resolution to go to her service, and I subsequently made sure that I sent it, because I didn't have her personal home address and didn't know the funeral home. So I sent it when I realized I couldn't make it. I sent it to her last immediately person she was accountable to, which was City Councilman Lewis. I sent it to him, and I also, so that complying with the Florida Sunshine and what we cannot do to communicate with one another, I almost sent it to the chair, but I didn't, so I sent it to Mrs. Tamara Pettis, and so that she would have it. And she and I kind of discussed it. So if it's something that we're not going to do, or if it's simply going to be a card, if something like that happened, I would like to know the posture of the board, if we want to acknowledge that person or not, and what's the appropriate way to do it.
Thank you.
And I do have a copy of the
Thank you,
resolution
Dr.
that I
Collins.
did.
I was able to attend the
Good.
memorial, and I am interested in reviewing such resolution. When things of that nature, and your heart is in a good place, I think you can't go wrong. So I commend you for doing what you felt was right, for the sake of yourself and the sake of the board. I have no problems with that, as long as it complied with Sunshine State laws. If you will, Mr. Irvin.
Yes, I'd like to second Dr. Collins' comments, and also say that I want to officially recognize her years of service to the city of Tampa. From what I understand, she was a great service person to this community, and that needs to be fully recognized. Thank you.
Thank you.
I asked a question.
Yes, if you will, Mr. Banks, Reverend Banks.
Appropriate that we officially accepted and adopted the resolution from the board, or would it be out of our purview to do that?
Well, Kamaria Pettis-Mackle from the City Attorney's Office. Dr. Collins did prepare the resolution. And Dr. Collins can explain, she wanted to provide the resolution to the family. So if the board wants to prepare a resolution or a letter acknowledging Mrs. Mercer's service to the CRB, I can assist with providing a letter to provide to the family and ensure that it gets to the family if that's what the board is inclined to do. The letter or the resolution that Dr. Collins provided, I could put it on the, well, you have a clean copy, we can put it on the podium for everyone to review, but if the board just wants to do a letter recognizing Mrs. Mercer's service to the board, and I can provide it to the family, that's also within your purview.
I guess my question was, can we affirm what she did after the fact, just for the record, because she was saying she did it, and she was concerned that she may have overstepped. You know, you just kind of affirmed something that was done.
I don't know that that's necessary.
Okay.
And I would say that even if a letter can be written on our behalf, I can't send you guys this because of Florida Sunshine. But I did send it if you guys wanted to be sent out to read it. I do have a hard copy of it here that I did bring with me, and you could read it and you might say, well, no, let's just do a letter to send something to the family. But I was just more concerned that she served us and I wanted it to be recognized.
Well, I would move that we do a letter so that it can be a part of our official record of the board acknowledging her contribution to our efforts.
So Reverend,
I'm sorry.
Reverend Banks is making a motion to create a resolution letter on behalf of the board.
Yes.
And if it's gonna be a resolution letter, if we can say now so that we will know somebody gonna do something on our behalf or we do it, I'm going with what Miss Mercer used to tell me to do. You say y'all was gonna do it, so, and all I have to do is remember how she said that even with the media. Can we establish the fact, cause, you know, we don't know who it may be, and if we wanna recognize the service of that individual. And that was quick, you know, you get something on a Sunday and you got a service on Saturday, and it usually been a delay and we never did have it. So I would say that if that's something that we want to do, even if the person say, well, I don't want if anything happen, that's their choice. But if it's something that we want to do and acknowledge the service of that individual, I'm fine with I'm fine with it if it goes to the family. I'm also fine with it if it goes to the service, as we do in our churches when they have acknowledgement, how the elected officials might send acknowledgement for the work that a person did, or the city, the mayor, or whoever. And we are a board that serves the citizen of the city, and she assisted us in doing our duties. So I would like us to consider.
Are you asking for a policy?
Not really a policy, because it doesn't really need to be a policy unless we decide it to be one. But and it's going to be an action that we take, and we're not in the policy making. I don't think
No.
at this time. No, we're just saying, do we do acknowledgements?
I mean, as a board, if that's your personal preference to do that, I mean, there's nothing wrong with you doing that personally. If you want to take action as a board, you have to meet together as a board to discuss that at the time,
Which is what I'm saying.
at a meeting. So if that's what you're asking, you would have to wait until we have a meeting in order to discuss that.
And I can understand exactly what you're saying. So if we could put this on the agenda for the next meeting, but in the meantime, we're discussing it now.
To
So
put what on the agenda?
if we want to do any kind of acknowledgement, any resolution letters, or anything like that, if that's something the board wanted to do.
You want to put that on the agenda to discuss next month?
Well, you just indicated, I thought we were discussing it now. That's why I was trying to get an amendment put on Reverend Banks, but if not, and if we need to have it separate and put it on the agenda and to discuss it, then
I believe, I think, I'm not speaking for the entire board, but a few of us have expressed our concerns, and I think we're all in agreement of a collective letter that Ms. Kamaria can provide to the family to acknowledge that we appreciate the services that she provided for us. I think that will be suffice as reference to moving forward under CRB staff reports and business. If we wanted to engage in this type of dialogue on worst case scenario, something this incident happens in the future, we would have a template already established. I have no problem with adding that to the CRB staff reports and business for next month, if that's your desire. Any further discussion?
and I'll just call for a question. Okay. That's it.
So, Dr. Collins, are you making a motion
No.
to add
I'm
a topic?
I'm just seconding the motion where Dr. Banker was asking the question, so if we could carry his motion so we can take care of this Mercer family now, we can address that afterwards.
Okay, so there is a motion on the floor in reference to, Reverend Banks made a motion to create a resolution letter provided by Ms. Kamaria Pettis Michael to the family recognizing her services to the CRB. Do I have a second?
It's been second. I'm just saying that was.
Dr.
second.
Carolyn Collins has seconded the motion.
Mhm.
Any further discussion? Go ahead now, continue with the vote. All those in favor, please show by raising of hand. Any opposed, please show by raising of hand. That motion passes. If you will, Ms. Kamari, if you can get that to the family as soon as possible in reference to the board,
Should that be shared with the board?
be greatly appreciated.
I will make sure, yes.
Thank you.
We'll continue with the agenda. Items continued, there are none. Moving on to item 11, announcements and news business, if you will, Mr. Valdez.
Thank you, Mr. Chair. I would like to bring up or back to light the case that we reviewed in February, case number 21F04 regarding Officer Boyd. I know last month we reviewed a presentation, a PowerPoint, and we also looked at a recommendation that we're going to submit to the chief that Ms. Camaris did for us. However, in doing some investigation in terms of research as it relates to different police departments and really went back to the case and read it and saw the facts, I came across what I think is what we were trying to communicate in our recommendation, which is a discipline matrix. So I would like to ask first if the city of the Hampton Police Department has a discipline matrix for their officers. If not, our recommendation would be to propose that the city of Tampa Police Department creates a discipline matrix. And basically what a discipline matrix does, it really eliminates disparities and ensures that officers who have been found to have committed similar forms of misconduct will receive a similar discipline. So if you guys, and I can share with you all, is this something that we can put on the screen? A sample of a matrix from a different department?
Sure, but Captain Mesmer, can you, I mean, I don't.
Sure.
So Mr. Valdez is sharing a briefing in reference to South Bend Police Department as an example of an example of the discipline matrix template that he's suggesting could be added into a recommendation for our Tampa Police Department in reference to the chief or to the city mayor.
And can I ask, is that relate,
Now,
is that in reference to that last case that we saw?
Correct,
where
in
we asked
February.
for? Okay,
Yep.
right.
So the discussion that we had during the February meeting was more so related to the severity of the violations and really having a discipline tied to that, and depending on the progressive of such discipline, that officer would be receive a discipline such to that nature of incident. So for example, in this very first form that we're looking from South Bend Police Department, their discipline matrix includes different levels. A level 1 is a minimal negative impact on department image or operations, and such violations can be a seatbelt violation, non-criminal traffic infractions, low speed at fault traffic, all the way to failure to advise of address or telephone change. So in their first violation, they'll receive a oral reprimand. On their second violation, they'll receive a written reprimand. And on their third violation, they'll receive a 2-day unpaid suspension. If you go further down to level 2, this consists of any of more than minimal negative impact on department image or operations relationships with other officers or the community. And such violations can be repeated violations from level 1, property damage, loss of department property, unauthorized leave, failure to have secondary employment approved. If the officer displays any of these violations, on their first violation, they'll get a written reprimand, which you can see is different from the above level that was on oral. Second violation will be a 3-day unpaid suspension. Third violation will be a 5-day unpaid suspension. So I know we had discussion in February as it relates to this specific case because the officer violated several policies as it related to the department, and he received a written counseling letter was what he received.
If you will, Captain Messmer, are you familiar with the term discipline matrix? Is that something that our law enforcement is aware of, this particular disciplinary action format?
Right, we don't specifically have a discipline matrix, and since this wasn't on the agenda, I wasn't really prepared to discuss anything about this, so I can take a look at it and go back, but we do use progressive discipline, and as you see on the right side there, it appears that there's progressive discipline based on multiple violations and different levels. I mean, we do, again, look at what have other officers received for the same violation, and we keep in accordance with that. And if we depart from that, then the union's going to grieve that. Now, if we were to implement a discipline matrix, so to speak, and informally put things down like that, that would be probably something that would have to be collectively bargained, because it would be a change to our discipline policy. I don't know what the Law Enforcement Bill of Rights is like in Indiana. I don't know if they're represented by a union, but we just can't implement things because somebody else has done it in another state. We would have to look at that. We would have to discuss that with counsel. We would have to sit down with the union. They probably would, if we just threw something like this out, they would, it's my opinion that they would probably file some sort of a grievance or unfair labor practice if we just did it without their knowledge, without their consent. So that would be something we would have to really take a very deep look at. And looking at these, I don't really think it really departs from anything that we do now. You know, in that, under the description, you know, talking about minimal negative impact on the department image or operations relationships with other officers of the community. And in that one case, there really was no impact with the community because that complainant, the person who was affected by it, didn't care enough to cooperate. So there would definitely be the argument made that, well, there was no impact in this case, so this officer shouldn't receive serious discipline. So I don't know what it's really solving because we do this now. We don't have it in a you know, Excel spreadsheet with columns and specific levels, but we do go off of progressive discipline, we do go off of past practice, and we do have defined serious policy violations that always result in termination for the most part. So again, I can take it back and look at it, but without knowing how that would comply with our contract, our statutes, and again, just by looking at it, I don't really think it's a departure from what we already do.
Okay. Thank you for sharing, Captain Messmer. And I do want to applaud the additional research and the going to the extra step. This is one of the things that I asked in the past for our members in reference to creating more recommendations to share in reference to policy change or disciplinary actions to the chief and to the mayor. So I do applaud your effort. I will like to have the opportunity to brief this sample discipline matrix. As Captain Messmer stated as well, when you speak about disciplinary actions, we do have policies in place. There's other entities in reference to Bill of Rights and unions and things of that nature that has to be looked at. But again, this is a very great start. I applaud you for this. I would like to have the opportunity to brief and get familiarity with the discipline matrix myself as well. And this may be something that we can add on the agenda so we can all have the opportunity to really engage into this matter and see if this is something that we want to look into in reference to creating some type of recommendation to our chief. Any further discussion?
I would say so that we don't just kind of do it, and I agree with the officer, but I like the concept. If we could have some kind of a parallel comparison on what we have now, and so we know that it's already been approved by the union, it's already in play, we see what we're doing, because I even go back to the case that we had with the police officer who did what he did with the kid in the car with his parent at home, and different things that occurred with that, and we should know what it was. It would be good to look at a comparison, and if we gave you time, I know, you know, to review this and to kind of look at it, so if you brought it back to us and say, you know, this is the same thing we're doing here, if we had a couple of months, it would be nice to have, put it on the agenda specific to bring it back so we could take a look at it. And not to say, that would help us determine if we wanted to say, hey, it's just one piece in here that looked pretty good, if we can look at that rather than looking at the total sum part.
Captain
So-
Mesmer, do you think that this is something that can be placed together in reference to a comparison of what Mr. Valdez has presented tonight versus what we already have in play? Is this something that we can add to either next month's agenda or the following month to give you the necessary time to go through this briefing and see how we compare with other cities and states?
I'm not going to be here next month. I'm going to have somebody else here. I'm going to be out of town at a conference, but, so probably in June, if you want to reapproach this. I don't know how receptive the executive staff and the union would be to something like this, that is going to clearly define certain things. We don't have something like this because for each and every violation we pull our own records from our case management system and look at all previous violations and give the same discipline. So we don't need a matrix to say that failing to appear at court is going to be a written reprimand. Failing to appear at court is always going to be a letter of counseling for us on the first offense because that's past practice and we have the documentation to do that. So the documentation exists in our systems, and the fact that we use those systems is written into our policy, but we don't have a chart that has that in there. We look at every case individually, and I don't think there's anything wrong with the way that we do that. So it would not be my suggestion to change our current practice and create a matrix when we do that on every single case anyway.
I definitely don't think we're there yet, but you know, just to the fact of public education and awareness, not to compare apples to oranges. I think this would be a great opportunity for the public to better understand our disciplinary tree and how we compare with other options that's out there, and just to applaud the energy that he has placed into this matter based off a previous case. I think this is something that the public may have some interest in. So I would like to add this to the agenda in June. And again, if nothing else, as public education and citizen awareness. And sometimes you place some things together, and even if we get one good aspect out of it, it was worth the energy. And again, even though that was not on the agenda, thank you for sharing. We will continue with the agenda.
I'm sorry, sir,
if we're unable to do that in June, just give us notification. I'm pretty sure this is a very complex issue, and we want to give it the attention it needs. So if June does not suffice, just inform the board, and we will table it until when it is necessary so it can have the attention it needs.
Yes, sir. If we could actually move that to July. So I'm going to be at conferences both in May and June. So I'm going to have one of my detectives standing in for me in May and in June, and I'll be back in July.
Great. July.
Mr. Chair, the next item on the agenda is regarding the presentation of the annual report, the CRB annual report to City Council. That date for the presentation of the report is going to be May 5th, 2022. It's at a time certain of 9 a.m. It'll be the first item on the agenda. So obviously, Mr. Chair, you will be there. I will be there to assist you in the presentation.
Right.
But the board members are welcome to come if you would like.
And I urge any, if not all members of the board, if possible, to be present, if applicable, for the presentation of the CRB annual report to City Council. This has been placed into the new ordinance, and it'd be great if one have the availability to show support. We'll continue with the agenda. For any, in reference to the meeting of next month, the fourth Tuesday of next month will be May 24th of 2022. Any further discussion is necessary for the upcoming meeting? Hearing none, we will continue with the next meeting on May 24th of 2022. for any reasons, if you're unable to attend the next meeting, I believe that we all received a confirmation email, and that seemed to get us a great response. I'd like to continue that so we can have notification. I understand that mercy does happen. However, if we can continue that template, it will give us notification that we do have a forum, and we can all, move forward together on that. So let's continue to do so. But for whatever reason, if you're unable to attend, please, if applicable, give 48 hours in advance to ensure we have a forum. Before I adjourn this meeting, I'd like to give the floor to any of our board members if you want to share any additional comments, statements, or concerns.
One question on parking. Where is
Parking.
parking? I know they had indicated where we could park somewhere, a couple of spaces under TPD, but it's getting worse. I don't know what's going on in the afternoon, but I was riding around in there.
I'm not sure about the parking situation.
Yeah. They told us.
If you will, Mike Schmidt, are you familiar with designated parking areas for CRB members during
I know they
the
had a couple of
CRB
spots.
meeting?
I don't know what's going on there.
I think we discussed allowing you to enter into the bottom part of the garage there. There's,
It's over here?
yes, right here. You enter off Florida.
If possible, could we get a
I can-
roadmap of that entrance area and
Because
the
my favorite
recommended
spot.
parking area for our members?
Sure,
To ensure that they can be present at 6 o'clock and not be
It's
riding
right
around
across the
looking for a
street.
parking space.
It's in that parking, and you just,
Right
and they'll let
across
us
the
go
street,
down
you
there?
Just drive
I
right
never
on
did
in
have
off
to
of
do
Florida.
that, but I can't get my handicap spots no more.
Any other further comments or statements? This meeting is adjourned.